Estrada versus Escritor is another beautiful case, no? In so far as religious rights are concerned. This involves, ito naman, religious freedom. This involves a court employee who was accused. Well, nireklamo siya because she was living with a man, not her husband. She was living with a man, not her husband. So merong galit sa kanya, nag-file ang case sa Supreme Court, sabi nila, under civil service rules, that is immorality, and under civil service rules, she should be dismissed from service. Did she deny it? No, she did not. Instead, she said that an exemption should be carved out. She should be exempted from the implementation of the law because of her religious belief. Pwede ba yun? Of course, pwede yun. And the Supreme Court said, we used the compelling state interest test. Okay? The compelling state interest test, no, first question is the law or the policy of the state putting a burden on religious freedom? Second, is that religious belief sincere? Not true, ha? We don't care if it is true or not, but is it sincere? And then third, is there a compelling state interest that justifies the burden on the citizen? And finally, is there no less intrusive means? In other words, wala na bang ibang paraan to achieve the state interest? Okay? So, that is the compelling state interest test. Okay? If the answer is that there is a compelling interest, yet there is another way of achieving that interest, and therefore it is unnecessary to put a burden on our citizen, then we can carve out an exemption. Okay? Kasi, basically, in this case, in Estrada versus Escritor, ang sinasabi ng Supreme Court, simple lang. Ano ba makukuha natin, no, kung pipilitin natin siyang humiwalay sa asawa niya? E nag-testify ang religious leaders niya. Sabi ng religious leaders, totoo po yan. Ayon sa paniniwala namin, yung lalaking yan ang binigay sa kanya ng Diyos. Okay? Yan ang asawang binigay sa kanya ng Diyos. So yan po talaga ang paniniwala namin. So religious leaders testified. There was a sincere belief. So ang tanong ng Supreme Court, okay. So first question, is the law putting a burden on her? Obviously, because the law is saying, hiwalayan mo yan o tanggal ka sa trabaho. Okay. Is there a compelling state interest? Morality in the public service. Okay, that is compelling enough. The problem is, wala na bang less intrusive means? Okay? Wala na bang less intrusive means? Kasi sa totoo lang, kung pinag-uusapan lang natin, morality in the public service, ganong karaming senador, presidente, congressman, di ba? Ang mas immoral pa dito sa court staff na to. Okay. So sabi ng Supreme Court, the intrusion is unnecessary because we can promote public morality in some other way, other than making her turn her back on her own religion. Okay? So the Supreme Court carved out an exemption for her based on religious freedom. Okay? Now, in Ebralinag, actually, the Estrada versus Escritor came later, nauna yung Ebralinag. Okay. Ebralinag is actually an exciting case, no? Because there was a similar case prior to Ebralinag, about 20 years before Ebralinag. There was Herona versus the city superintendent of schools. Exactly the same facts. What are the facts? Children, public school children who belong to the Saksi ni Jehovah's Witnesses. Okay? During flag ceremony, they refused to salute the flag and they refused to swear an oath, yung palatang makabayan. Pero nakastand at attention sila, hindi sila nanggugulo, quiet lang sila. Winarningan sila. Pag hindi kayo kumanta, pag hindi kayo sumaludo at hindi kayo magpalatang makabayan, we will discipline you. Pinaliwanag ng mga bata, it is their religious belief, which is a Christian belief, that you should not honor false gods. That's a Christian belief. Isa lang ang Diyos. Wala kang ibang Diyos na iba. Except that, in the Jehovah's Witnesses interpretation, to salute a flag is to salute a false God. To swear allegiance to the country is to swear allegiance to a false God. So they don't want to violate their beliefs. Okay. In the Herona case, nung nakarating, so ang nangyari sa kanila, they were expelled. Public school children were expelled. Nakarating ng Supreme Court, in the Herona case, simple lang ang handling ng Supreme Court. Sabi ng Supreme Court, kayong hindi gumagalang sa bayan namin, wala kayong karapatang humingi ng tulong ng batas namin. Ganun lang kasimple. Okay? Sounds logical, pero, diba? Nagkaroon sila ng chance in the 1990s to bring the same issue back to the Supreme Court. Because same exact facts. Public school children refused to salute the flag, refused to recite na panatang makabayan, in-expel. They went back to the Supreme Court. This time, we had a more open-minded Supreme Court. And the open-minded Supreme Court asked the question, what do we get? What will the state get by punishing these children? What will we get? And we are punishing them because they're believing in a religion. Okay. Sabi ng Solgen, love of country. And the truth is, daming politiko dyan na makakanta ng bayang magiliw, sumasaludo sa flag at saka nagpapanatang makabayan pero ninanakawan naman ng bayan. Diba? At hindi pinaparusahan. Bakit itong mga batang to hindi lang naman kumakanta? What do we get out of punishing them? So in this case, dito nagsimula yung, sabi ng Supreme Court, why should we punish them? Diba? If we want to promote love of country, can we not do that without putting a burden on their religious practice? And the Supreme Court said, we can. So why should we punish these children? Okay? Yan ang naging precursor nung Estrada versus Escritor. Yan yung naging precursor ng attitude na benevolent neutrality. Okay? Victoriano and Elizalde Rope Workers Union, this is a law that was used to amend the labor code. If you took up labor law, you are aware, of course, of the closed shop, diba? Closed shop agreement in CBA. Bakit yung mga mukha nyo parang, ano yun? Diyos ko, malapit na kayo mag-bar. Closed shop agreement, recognized yan by law. If there is a recognized bargaining agent and the management and they agree on a CBA na closed shop, what that means is any employee who is not a member of the union may be removed for cause for not joining the union. Okay? That is recognized by law as a stabilizing industrial peace. Okay? So pag may closed shop agreement, ikaw hindi ka member na union, bibigyan ka ng time, sumali ka or tatanggalin ka namin. Recognize yan as a valid cause for termination. Now, a law was introduced amending the law saying na unless, nilagyan ng unless his religious beliefs prevents him from joining a union. Okay. So, sabi nung iba, isa lang naman ang reliyon sa Pilipinas na laban sa union. So, yung legislation na yan is simply to support that religion. No? Sabi ng Supreme Court, hindi. Ayun naman. Hindi. It is to protect the religious freedom of an individual. Because under Section 5 of Article 3, di ba? State will not establish any religion, but it will not interfere in the free exercise of religion. So, while we can require a person to join a union for purposes of industrial peace, if joining a union violates his religious belief, then he should have the freedom to make that choice. Okay? Infonasher versus CA. This is an intra-church conflict where a bishop sued another bishop, no? And nag-aaway sila regarding church properties. One of the factions, one of the warring factions went to court. The other faction said, teka muna, hindi pwedeng mag-interfere ang state through the courts in an intra-religious conflict. So the Supreme Court here had the opportunity, no, and said, teka, that must be qualified. So sabi ng Supreme Court, saan pwedeng mag-interfere ang court? The court can interfere, okay, if they can look into jurisdictional issues. Meron bang issue yung religious tribunal to decide rights? Okay. Second, regularity of their procedure. Was any citizen deprived of life, liberty, or property on the ground of their religious practices? Okay. And then, fairness. Okay. Was there arbitrariness? Was someone deprived of due process? Yan pwedeng pakialaman ng korte. On the other hand, ang hindi pwedeng pakialaman ng korte, lumabag ba siya sa banal na libro? Okay? Hindi pwedeng desisyonan ng korte yan. Okay? Tinalikuran ba niya ang paniniwala ng relihiyon? Hindi pwedeng sagutan ng korte yan. Because those are purely religious matters. Ang pwedeng pakialaman lang ng korte, yung civil matters, especially if it involves life, okay, liberty, or property. Other than that, yung religious beliefs niyo, hindi namin pwedeng pakialaman yan. So, pag nag-aaway ang dalawang paksyon ng korte, ng relihiyon, pwede ba sila pumunta sa korte? Oo, insofar as their civil rights are concerned. But insofar as their beliefs are concerned, sino ang tamang paniniwala at sino ang maling paniniwala, hindi pwedeng makialam ang korte dyan. Republic versus Manalo is a case that you have discussed in persons. You know this, di ba? Article, if I'm not mistaken, I'm not a persons professor. But this involves that article in the family code that says when a Filipino spouse is married to an alien and the alien obtains a divorce and his national law allows him to remarry, that will also allow the Filipino spouse to remarry. You remember that? Okay, in family code. Okay. The Catholic Church wants to interpret that provision to mean that is only applicable when it is the alien spouse who obtains a divorce. And so this is that case, no? Because in this case, it was the Filipino spouse who obtained the divorce. And so the oppositors are saying, ay, hindi pwede yan. We only allow that if it is the alien spouse who obtains a divorce. Okay. Sabi ng Supreme Court, teka muna, isipin muna natin, bakit ba natin inaalaw? Hindi ba inaalaw natin yan kasi kawawa ang kababayan natin? Can you just imagine his national law or her national law allows her to remarry? Tapos in our law, ang ating kawawang kababayan ay alipin pa rin ng lintik na marriage na yan. The reason is that. Okay? That is the reason behind the law. Would it matter who obtains the divorce? It doesn't matter who obtains the divorce. Ang ending pa rin, ang kawawa yung Pilipino. And that is the reason behind the law. Kaya sabi ng and then in municipality of Tangkal versus Balindon, this involves a Muslim who sued the municipality for the return of property. Kasi nag-donate siya sa municipality ng lupa. He claims the municipality failed to comply with the conditions of the donation. But he sued the municipality in a Sharia court. So yung municipality moved to dismiss. Sabi nila, walang jurisdiction ng Sharia court. Sabi ng petitioner, well, under Sharia law, I can bring this before the Sharia court if the plaintiff is Muslim and the defendant is Muslim. Since the mayor of the municipality is Muslim, the Sharia court has jurisdiction. Is he correct? Of course not. Sabi ng Supreme Court, teka lang. Hindi porke Muslim yung mayor, Muslim ang municipality. In fact, hindi pwedeng magkaroon ng relihiyon ng municipality because there is separation of church and state. Iba yung pagkatao ng mayor, iba yung municipality. Okay? So to say that because the mayor is Muslim, the municipality is Muslim is legally wrong. Therefore, the Sharia court has no jurisdiction.